A bombshell suppressor ruling just dropped, and the Department of Justice did the unthinkable. They completely reversed their position and admitted NFA suppressor rules violate the Constitution. This changes everything for 2.6 million suppressor owners. Hit subscribe now, because what you're about to hear will blow your mind. The confession that changed everything. The federal government just filed a 47-page admission that they've violated your rights for nearly a century after spending $400,000 defending these regulations. The same DOJ attorneys are now destroying every argument they previously made. This reversal happened across 6 federal circuit courts simultaneously, making it impossible to call it an isolated mistake. Yes, the 156-page defense brief from September 2025 is now being used by gun rights lawyers as evidence of government bad faith. The feds just admitted they've been wrong for 90 years. On January 20th, 2026, the DOJ filed a 47-page document confessing that suppressor regulations violate the Second Amendment. This wasn't a technicality or minor adjustment. This was complete institutional surrender in United States versus Patterson. The same legal team that defended these regulations spent $400,000 of taxpayer money writing a 156-page brief just 4 months earlier. Now they're dismantling every argument they made. They conceded suppressors are in common use, with 2.6 million registered units, admitted the 200 tax creates financial barriers, and acknowledged no historical precedent exists from America's founding era. Yet the reversal expanded beyond one case. DOJ attorneys filed position changes across 6 federal circuit courts simultaneously, from Arizona to Maine. Cases that consumed 3 years of litigation suddenly collapsed as government lawyers withdrew opposition. Legal fees totaling millions evaporated overnight. But here's what most people missed. The DOJ specifically limited this confession to suppressors only. They explicitly stated this should not apply to machine guns, short-barreled rifles, or other NFA items. The government was trying to sacrifice one category to save the rest. The court, however, had different plans. The instructor who accidentally broke the system. A shooting instructor trying to save his hearing just accidentally dismantled 90 years of federal gun control. Yes, Patterson waited 11 months for suppressor approval while buying 3 other firearms in under 45 minutes, all with the same background check. His permanent 40% hearing loss became the medical evidence that exposed the absurdity of treating hearing protection as a regulated weapon. The 650 suppressor he bought would have reduced gunfire from 165 decibels to 132 decibels, still loud enough to require ear protection, but below the permanent damage threshold. Michael Patterson never intended to become a constitutional warrior. He's a firearms instructor in Scottsdale, Arizona, running a training academy that teaches defensive shooting to law enforcement and civilians. After 15 years of instruction, he developed permanent hearing damage, 40% loss in his right ear, and constant tinnitus that prevents him from sleeping without white noise machines. His audiologist delivered a stark warning: continue teaching without better protection and face complete deafness by age 50. Electronic earmuffs weren't enough because instructors need to hear student questions and range commands. In March 2024, Patterson purchased a Silencer Co. Omega 9K suppressor for $650, not as a political statement, but as medical equipment to save his remaining hearing. The bureaucratic maze he entered was absurd. Patterson submitted 2 sets of fingerprints, passport photos, and notified his county sheriff. He filled out an 8-page ATF Form 4 and paid $200 for permission to protect his ears. During the 11 months and 17 days, his application sat waiting. He purchased 3 regular firearms approved in under 45 minutes combined, all requiring the identical FBI background check. The Firearms Policy Coalition approached him about challenging the constitutional framework. Patterson agreed on one condition: the case must seek relief for every suppressor owner in America, not just him. He filed suit in September 2024, and District Judge Sarah Henderson issued a 73-page ruling in his favor. Then the DOJ appealed to the one place where Second Amendment claims go to die. The irony wasn't lost on anyone. The government made Patterson wait nearly a year to protect his hearing, while approving actual firearms in minutes, proving the system was never about safety. The court where gun rights go to die. This 3-judge panel had ruled against gun rights 67 consecutive times until now. Yet the Second Amendment Foundation allocated $280,000 just for the appeal, expecting complete defeat and preparing for a Supreme Court battle. Gun rights organizations were so certain of losing that they drafted 3 separate Supreme Court cert petitions before the Ninth Circuit even issued its decision. The Ninth Circuit Court of Appeals had ruled against gun rights in 23 consecutive cases since June 2022. 2022, 23 straight losses. They upheld California's assault weapon ban, magazine capacity limits, ammunition background checks, and even restrictions on firearm advertising. This circuit covers 9 Western states and 65 million Americans. The 3-judge panel assignment was devastating. Judge Paul Watford previously upheld California's 10-day waiting period, even for people who already own firearms. Judge Andrew Hurwitz authored Hawaii's open carry ban decision. Judge Jacqueline Nguyen had never voted to strike down a single gun regulation in her entire career. Their combined record: 0 wins for gun rights across 67 cases. Gun rights organizations prepared for catastrophic defeat. The Firearms Policy Coalition war game scenarios, where the Ninth Circuit would issue an opinion so hostile it would create binding bad precedent across the entire West. Oral arguments were scheduled for January 28, 2026. Then something extraordinary happened 8 days before that hearing. The government's confession of error meant oral arguments never occurred. Instead of the expected disaster, Patterson won a unanimous decision from the most anti-gun panel in America, the Supreme Court test that destroyed 90 years of law. Yes, the 2022 Bruin decision created a constitutional test that the government spent $225,000 trying to pass and failed completely. DOJ researchers searched for 7 months through founding-era laws and found absolutely nothing that could justify taxing suppressors. The 2022 Supreme Court decision in New York State, Rifle and Pistol Association versus Bruin, eliminated the way courts had analyzed gun laws for decades. Previously, courts used a balancing test weighing government interests against individual rights. The government won almost every case because judges could simply declare public safety more important than constitutional rights. Justice Clarence Thomas wrote that the Second Amendment is not a second-class right subject to interest balancing. The new standard requires 2 steps. First, does the constitutional text cover this conduct? And second, if yes, the government must prove the regulation matches America's historical tradition from the founding era. No balancing, no exceptions for public safety. This created an impossible problem for suppressor regulations. Hiram Percy Maxim didn't invent suppressors until 1902, receiving his patent in 1909. They literally didn't exist in 1791, when the Second Amendment was ratified. There cannot be founding-era regulations of technology that didn't exist yet. The government needed historical analogs, similar regulations from early America that burdened rights in comparable ways. The DOJ commissioned 2 historical studies costing $225,000 combined. Researchers searched for 7 months and found colonial-era gunpowder storage laws, dangerous instrumentality regulations, and British poacher restrictions. Every analog failed, and the government found nothing that survived scrutiny. 3 pillars that demolished federal gun control. An 89-page unanimous opinion just established 3 independent legal reasons why NFA suppressor regulations are unconstitutional. Each pillar stands alone as sufficient grounds to strike down the law. Chief Judge Jacqueline Nguyen's opinion rests on 3 independent legal pillars, each sufficient by itself to destroy the suppressor provisions. The opinion is binding precedent across 9 Western states, covering 65 million Americans. Legal scholars are calling it the most important Second Amendment decision since the 2008 Heller ruling. Pillar 1 addresses common use. The government argued 2.6 million suppressors represent only 2% of gun owners, making them unusual. Judge Nguyen demolished this by noting that's more than the entire active-duty U.S. military and shows 622% growth since 2012. The opinion states governments cannot claim items are unusual when their own regulations prevent those items from becoming common. Pillar 2 addresses the 200 tax as prior restraint. In 1934, when the NFA passed, 200 equaled 2 months of average salary. Today, it's a 30% tax on a 650 device. The court compared this to poll taxes that were struck down and protest permit fees that were eliminated. Constitutional rights cannot require payment to exercise. Pillar 3 addresses administrative delays as effective prohibition. Patterson waited 11 months while the ATF had no statutory deadline. Some applicants wait over 18 months with no recourse. Yet the court ruled that a registration system with no time limits constitutes a de facto ban. What actually changes starting now? The court issued a 90-day implementation timeline that ends 200 tax stamps, eliminates year-long waits, and triggers $69.4 million in refunds starting January 23, 2026. Buying a suppressor now takes minutes, just like any other firearm. Effective January 23, 2026, the ATF must stop collecting 200 tax stamps. Walk into any gun store, select a suppressor, fill out the standard Form 4473, wait for instant NICS approval, and leave same day. No fingerprints, no photos, no ATF Form 4, no 11-month wait for 347,000 pending applicants. The ATF has 14 days to auto-approve every application by February 6th, 2026. By April 23rd, the ATF must refund all 200 payments for applications submitted after January 1st. Yet 2024, anyone currently in lawful possession of any firearm is now deemed a lawful suppressor possessor without registration. The NFA registry for suppressors becomes obsolete. The state law trap nobody's talking about. 8 states still have suppressor bans that can send you to prison for 3 years, even though federal law no longer prohibits them. California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, and Hawaii. If you live in these states, you're still committing a felony by possessing a suppressor. California Penal Code Section 33,410 makes suppressor possession a felony with up to 3 years in state prison. These are independent criminal statutes that remain fully enforceable. State police could arrest you even while federal ATF agents cannot. However, the 14th Amendment incorporates the Second Amendment against state governments. If federal NFA suppressor provisions violate the Constitution, then identical state provisions also violate it. California has a pending suppressor ban challenge that was stayed awaiting federal developments. That stay lifts immediately, and attorneys estimate at least 5 of the 8 states will lose their bans within 12 months. The domino nobody expected. The court's guidance section just gave attorneys a roadmap to eliminate short-barreled rifle restrictions. Judge Nguyen wrote she could find no principled distinction between an AR-15 pistol and rifle with identical barrel lengths except the 200 tax. Short-barreled rifles have been NFA items since 1934. The government's justification was always that SBRs are concealable. But the opinion points out that millions of Americans legally carry concealed handguns in all 50 states. Approximately 4.2 million AR-15 pistols with barrels under 16 inches are already in civilian hands. Judge Nguyen found no principled distinction between an AR-15 pistol with a 13-inch barrel and an AR-15 rifle with a 13-inch barrel, except one requires 200 and one doesn't. 3 lawsuits challenging SBR provisions were filed within 18 hours of the Patterson decision, all strategically filed in the Ninth Circuit. Legal experts give these cases 95% success probability. There's no founding-era precedent for 16-inch barrel requirements. That number was chosen arbitrarily in 1934. The ultimate constitutional showdown coming. And the legal framework that destroyed suppressor regulations is now being applied to the 1986 machine gun ban, and it could eliminate the Hughes Amendment entirely. Before the 1986 freeze, machine gun registrations grew at 15,000 to 20,000 annually. Continuing that growth would mean 1.2 million registered machine guns today. The 1986 Hughes Amendment prohibits civilian possession of machine guns manufactured after May 19, 1986. This created a closed registry of approximately 630,000 transferable machine guns, artificially driving prices from $600 manufacturing cost to $15,000 to $40,000 market value. The opinion explicitly states governments cannot argue something is unusual when their own regulations prevent it from becoming common. But Patterson holds that registration and taxation requirements are unconstitutional prior restraints. The Hughes Amendment doesn't merely tax or register machine guns, it bans them entirely. If a 200 tax violates the Second Amendment, an absolute prohibition certainly does. The Firearms Policy Coalition confirmed they're preparing a Hughes Amendment challenge for filing in the Fifth Circuit. They're recruiting FFL manufacturers currently possessing post-1986 machine guns as dealer samples. The timeline is 2 to 3 years to reach the Supreme Court, but Patterson established the constitutional framework that makes this challenge viable for the first time since 1986. The National Firearms Act is crumbling in real time, and most gun owners have no idea this is happening. If you want to stay ahead of every major development in firearms law, hit that subscribe button and turn on notifications right now. Like this video, share it with every gun owner you know.